In our last videos, we saw how Section 92 of the Australian Constitution deals with the absolute freedom of trade and commerce and the freedom of intercourse among states. Today, we will look particularly at the intercourse limb, but we will do it through a different perspective. Let's see what the High Court had to say about the intercourse limb in a case related to the border closures due to the COVID pandemic. Hello everyone, my name is Renato Costa, this channel is called Aussie Law, and today we will look at Palma and Western Australia from 2021. Do you remember that I said that Section 92 is usually viewed as having two limbs? We have the trade and commerce limb and we have the intercourse limb. This was affirmed by the High Court of Australia in a case called Cole and Winfield from 1988. You should take the time to watch that video in case you haven't done so. So just click on the top right corner and it will take you there. Watch that video first and then come back to this one. But in case you have already seen it, now is the time for you to make sure that you are subscribed to our channel by clicking the subscribe button. So the freedom of intercourse has been seen as something different and judged differently by a different standard than that of the trade and commerce limb. As expressed in Smithers from 1912, the intercourse limb has been considered a personal right of migration and movement from one part to the other of the Australian continent independently of any state borders. It did not have the same restrictions as the other limb, the trade and commerce limb. So, when analyzing the cases related to the intercourse limb, the court does not need to decide whether there is a discriminatory burden of a protectionist kind. Generally, the understanding of the courts is that if a law targets specifically to prevent intercourse among states, then that law will be invalid. However, if the burden on intercourse happened as an incident to another purpose, a justifiable purpose, then that law could be considered valid. But the thing is that the High Court has never really been invited to decide on the precise contours of this so-called individual right. At least not until Clive Palmer decided to challenge the border closures of Western Australia during the coronavirus pandemic. So now let's look at this decision in Palma and Western Australia from 2021. Let me start with a parenthesis because I want to tell you a little bit more who Clive Palmer is. Clive Palmer is a businessman with holdings in many relevant sectors of Australia's economy. He has been a member for the Parliament for Queensland for a term, and he is currently the chairman of the United Australia Party. Okay, so what happened in this case? According to the Emergency Management Act from 2005 in Western Australia, a minister could declare either part or the whole of the Western Australian state as a state of emergency. To do that, the minister had to be satisfied with certain conditions. Among these were that the extraordinary measures were required to prevent or minimize loss of life or harm to the health of persons. So some provisions of this act prevented the movement of people in these emergency areas, as declared by the minister, as long as they served the purposes of preventing or controlling or abating the risks that related to that emergency. An epidemic was considered an emergency by the Act. So in March 2020, under the Act, the Minister for Emergency Services for Western Australia declared a state of emergency that encompassed the whole of the state of Western Australia. In the following month, the Commissioner of Police for the state issued directions to give effect to the declaration made by the Minister. These directions, they are regulations or subordinate legislation. I've talked about this possibility in another video that you can watch by clicking on the top right corner. Well, the border closure direction was issued in April 2020 and it effectively closed the borders of Western Australia. There were some exceptions, it's true. Essential workers like healthcare providers or security officers could still get in, but most of the people was now prevented from entering Western Australia. Clive Palmer, he's a Queenslander, but he's a general manager for a really big business whose records are held in Western Australia. So he was used to traveling to Western Australia quite often because of this business. Under the direction, however, he was now prevented from entering Western Australia. Palmer challenged then the validity of the Act and the directions, saying that they were invalid because they were breaching Section 92 of the Australian Constitution. The matter was heard by the High Court in November 2020. The issue before the High Court was whether the Act and their directions infringed on Section 92 to the extent that they prevented the free movement of people, of intercourse among states. There was also a claim whether the border closure infringed on the first limb of Section 92 in terms of trade and commerce by imposing a burden of a protectionist kind. This is a very interesting case, isn't it? Because here Palma is forcing the High Court to make a decision on the precise limits of the intercourse limb. Is this supposed to be an individual right? Or is this again limiting the parliamentary powers and therefore this is to be considered just an express right? The High Court decided that the Act and the directions were valid. It was a unanimous decision of 5 justices because the other 2 were about to retire and did not sit in the case. Chief Justice Kiefel and Justice Keane wrote a joint judgment. Justice Gageler, Gordon and Edelman wrote separate judgments. You're now asking, what was the reasoning of the case and why is this case relevant to our understanding of Section 92 of the Australian Constitution? I'll tell you. First, the decision may have erased the dividing line between the 2 limbs of Section 92. In Palma, each of the justices decided that Section 92 prohibits a discriminatory burden. The majority said that the law will burden the intercourse limb only if it relates to preventing interstate movement, not intra-state movement, and that a law will still burden the trade and commerce limb if it imposes a burden of a protectionist kind. Justice Edelman disagreed to the extent that, for him, there was no need for either of the limbs to consider the protectionist kind of the burden. It was only necessary to consider the burden as a discriminatory burden. So in that particular aspect, Justice Edelman kind of went against the decision in Cole. For him, both limbs only demand a discriminatory burden. It does not need to be of a protectionist kind. So this has been deemed by some scholars as a reintegration of the 2 limbs of Section 92, creating a composite freedom of trade, commerce and intercourse. It does not matter if it is in trade, commerce or intercourse. If there is a discriminatory burden, that burden is prohibited, except if the burden is reasonably necessary or proportionate. So it means that if the discriminatory burden is still imposed to achieve some other constitutionally permissible purpose, then it might be admitted as valid law. And this brings us to the second point. The decision showed that the proportionality test, the structured proportionality, is gaining traction in the High Court. The majority of the justices in Palma found that this was an appropriate tool to assess whether the purposes of the law could be achieved by imposing such a discriminatory burden. We do have a video about the characterization of laws and proportionality, so you know what to do. In Palma, the High Court of Australia held that if a law discriminates against interstate intercourse, it must be justified by a legitimate end. Chief Justice Kiefel, with Justice Keane and Edelman, defended the structured proportionality test. Justice Gageler and Gordon defended the reasonable necessity test. Both tests serve to ensure that the discriminatory burden is justified under Section 92 of the Australian Constitution. And finally, the High Court has once more demonstrated that Section 92 is much more about limiting the powers of the Commonwealth Parliament rather than giving an individual right to a person. Again, when we look at Section 92, we don't quite see an individual right, but a freedom from the encroachment of the legislature in one's life. The case of Palma once more demonstrates that Section 92, if it is about trade and commerce or intercourse, is not an individual right, it's more like an express right, with quotation marks. I hope you enjoyed this video and I hope to see you again soon. Until then, ciao.